United States District Court for the Western District of Washington is now in session. The Honorable Thomas S. Dilley presiding.
Good morning, ladies and gentlemen.
Good morning.
Good morning. Morning.
Clerk, please call the calendar.
Thank you, Your Honor. Case number CV 12-1548Z, David Baxter versus MBA Group Insurance Trust, Health and Welfare Plan et al. For the record, counsel, will you please stand and make your appearances?
Good morning, Your Honor. Ian Burke and Catherine Knudsen from Keller Rohrbach representing David Baxter, who is here in the courtroom with his wife, Kathy
All right.
Moore.
Good morning. Welcome.
Good morning, Your Honor. Medora Marsa on behalf of the defendants with Derek Little from Carr-Tuttle Campbell and Donna Sheely from Regents Blue Shield.
Good morning.
Good morning.
This matter comes before the court on cross motions for summary judgment. Plaintiff's motion is docket number, I believe, 14, and defendant's motion is docket number 25. They're both noted for May 31st, I believe. That hasn't stopped the lawyers from filing matters since that time. I want to address that matter first before we get started. When we get started, I'm going to permit because we have cross motions for summary judgment, and basically they are arguing counter positions, but basically the same issues. I'll let the plaintiff go first, and you can save whatever part you wish for rebuttal. I think we've indicated a half hour per side, so if you wish to reserve some time, just let me know. But I wanted to address a couple of things that perhaps you need to know and or tell me about during your presentations. There was a decision made. This is an ERISA case, of course, but the first decision was made on November of 2011, I believe. There was an appeal. The first appeal was filed in February 2012 and perhaps decided in February of 2012, and there was a second appeal, and that was, I believe, resolved in July. The point is, in looking at the information that the court must consider in making a ruling, where do we draw the line? In other words, if Regents makes a decision, which they did in November of 2011 based on the information that was provided, if I'm to make a de novo review of the record and decide the issues, do I cut it off at that time based on what was presented? Because both sides have presented additional materials outside the administrative record, and so I need to understand kind of what your positions are on that subject. There is pending a motion to strike Dr. Rainey's declaration. That declaration is docket 22. The motion to strike was contained in the plaintiff's response, which is docket 30. That motion to strike will be denied. The court will consider the Rossi second declaration, docket 31, which was filed to rebut the Rainey declaration. I think plaintiffs had suggested that was an alternative and perhaps a better way to approach it, and I agree. So I will be considering that. The plaintiff also asked for costs in preparing the rebuttal report. I'm going to deny that. But yesterday we had yet a third Rossi declaration filed. I don't even know if the defendants, whether all the lawyers have seen it, but it is troubling to me that these declarations keep getting filed. So in your arguments, please help me understand where we draw the line. The Rossi declaration that was filed sometime yesterday, we found it only this morning. Perhaps my law clerk found it late yesterday. But in any event, it doesn't appear to respond to the Rainey declaration. It appears to present more argument, which usually is left to the lawyers, and it presents matters which presumably were available to Dr. Rossi long ago, and I fail to understand why a declaration should be filed at such a late moment here, particularly when we've had these cross motions for summary judgment that were filed long ago with a noting date almost a month ago. The purpose of the noting date is to get all of the papers before the court so we can consider what appropriate decisions are to be made. And if lawyers keep filing more paper, it's kind of like a moving target. So please address the matters that I've suggested be considered as part of your arguments. I'll hear from Mr. Burke. I guess you're going to be presenting for the plaintiff?
That's correct, Your Honor.
Welcome. You may proceed.
Thank you, Your Honor. I want to begin with the court's first comment about the administrative record in a de novo case. And the significance of it being a de novo case, to my understanding, is that the court's not limited at all by the record. The court simply proceeds to ask, is the treatment that Mr. Baxter had covered by the contract? And the court takes evidence on that question like it would in any civil case.
Well, but that's but de novo also means that it's an administrative record. It's a decision that the carrier makes at a time in a certain time, and why shouldn't that de novo review be based on the record that the insurance company received at the time it denied the benefits?
Because it's a de novo review of the question of what the contract covers, not a de novo review of the correctness of the insurance
What case do you
company's decision.
rely upon that would suggest that this can be, I mean, if there were a study that came out last night at midnight that was pertinent to the issues here, your position is that they should have known about that study, and somehow if it was favorable to your position that I should consider it in a de novo review? Is that your position?
No.
All right. Well, then help me understand what your position is.
My position is not that they should have known about something that came out last night.
Well,
but my position would be that the court would be able to consider it. And the reason for that is...
What Ninth Circuit case do you rely upon for that proposition, sir?
I forget.
I don't know that case.
Yes, I know you don't, Your Honor.
All right.
The reason that some ERISA reviews are limited to the administrative record is that some ERISA reviews, indeed many, are governed by the abuse of discretion standard. And a carrier like Regents cannot abuse its discretion by not looking at something it didn't have. And so that was the reason that the Ninth Circuit came to the conclusion in a case I forget that the record's limited in an abuse of discretion case. But in a de novo case, there's no deference. It doesn't matter what Regents decided. And the issue before the court is not, was Regents right or wrong? The issue before the court is, factually, is the treatment that Mr. Baxter had covered by the contract.
All right. Why should I consider this last-minute submission by you of the late-filed declaration?
I'm happy to address that, Your Honor, and certainly I'm cognizant of the timing issue, and I expected the court to bring it up. Mr. Baxter filed an administrative appeal in February of 2012, and in that appeal, his treating doctor at Loma Linda, Dr. Grover, offered the opinion that proton therapy can achieve the same level of cancer control as X-ray therapy while relying on total radiation to the body that was 2 to 3 times less than the total radiation that would be required for X-ray therapy. In this case, the defendant's experts submitted reports, and they did not take issue with that opinion by Dr. Grover. We then submitted a rebuttal report by Dr. Rossi in which he again asserted that medical opinion. For the first time in Regents' response brief on these cross motions, Regents suggested that that number lacks foundation And for that reason, Regents argues that Dr. Rossi's opinions in this case on that issue are not admissible. We had 4 days in which to prepare a reply brief, and we said in our reply that we were going to respond to that issue, and that's what Dr. Rossi's new declaration is. And here is the important thing for the court. When they say that that figure, 2 to 3 times less radiation, sometimes it's 2 to 4 times less radiation, and the reason for that is spelled out in Dr. Rossi's new declaration. When they say that's not based on anything, that is dead wrong. And that is the purpose for which we have offered Dr. Rossi's new declaration. And indeed, it's critical to the central issue in this case.
All right, why don't you tell me about the merits? Who has the burden of proof here? And,
Thank you, Your Honor. Regents has the burden of proof. And Regents has the burden of proof because it's relying on a contract exclusion. I'm not going to spend too much time on this because we're walking on a field that my guess is the court has great familiarity with and probably has its own views on. Both sides have relied on the Farley case from the 8th Circuit. And Farley concluded in that case that medical necessity was part of the...
As I understand it, if it's an issue of coverage, the plaintiff has the burden. If it's an issue relating to an exclusion, the defendant has the burden. That's well-established 9th Circuit law, you would agree?
That's Hornbook insurance law.
All right.
With one...
Yeah. It seems to me in this case we have a situation where we've got the crucial language contained both in the coverage portions of the policy and in the exclusion. And the Farley case and a couple of other circuit cases have dealt with similar situations and have suggested that the plaintiff has the burden. So why don't you respond to Farley and that issue?
I disagree with the suggestion that the medical necessity language occurs in the coverage section. And if I may run back to my table for 1 second, I'd like to put a piece of paper up on the board that's part of the record.
Certainly. Well, the introduction to the medical benefits section provides, you might put that up on the screen if you'd like, that to be covered, medical services and supplies must be medically necessary.
That's exactly the page I was putting up, Your Honor.
All right. Well, I assumed that you were going there. Doesn't that suggest that coverage requires that the services be medically necessary?
It might suggest that, Your Honor, if it were not preceded by something entirely different. This section is not the section of the contract that tells you what's covered. Every insurance contract has a line in it that says somewhere, we cover this or we cover that. That's not on this page. This page is an introduction to a very long section in this contract called medical benefits. If you start reading this section, it doesn't say anything about coverage. It begins with a paragraph that says, in this section, you will learn about your health plan's benefits and how your coverage pays for covered services. It goes on. I won't read it because it's not germane to what we're talking about. And then it says, all covered benefits are subject to the limitations, exclusions, and provisions of this plan, and then has the sentence that Your Honor referenced. Reading that doesn't tell you anything about what's covered. It doesn't tell you anything.
How is our case different than the Farley case out of the 8th Circuit, which dealt with what appears to be a very similar problem, and that is trying to decide whether it's part of the coverage, whether it's an exclusion, and who has the burden?
Because in Farley, the plan had been specifically amended, and the decision talks about the amendment number 8 to the plan. And in the amendment number 8 to the plan made absolutely clear that to be covered, something had to be listed as a covered service, and it had to be medically necessary. And then it had an arguably exclusionary language, but not, as I recall, denominated expressly as an exclusion, that we don't cover care that's quote-unquote not necessary without a particular reference to medical necessity. In this case, the contract has this introductory section that doesn't say anything about what's covered, and then it proceeds to a list of what's covered. And one of the things that's covered is medical services. And this is the what we cover section of the insurance contract that every insurance contract has. You have a loss and you go to your insurance contract and you ask, what do we pay for? And it says we cover professional services and supplies, including the services of a provider whose opinion or advice is requested by the attending provider, that are generally recognized and accepted non-surgical procedures for diagnostic or therapeutic purposes in the treatment of illness or injury. And in the Farley case, that we cover language was qualified by medical necessity. Nothing in this contract exists like that. Then, this contract proceeds, as every insurance contract does, to set forth a list of specific exclusions denominated as exclusions. And as we've put in our brief, one of the exclusions is an exclusion for services that are, quote, not medically necessary. The Farley court dealt with no such exclusion. There was never an express exclusion denominated as such in the contract that the Farley court looked at, like we have in this case. One of the things that Regents has not disputed is that an ERISA insurance contract is subject to the general rule of insurance contracts that ambiguous language is construed against the insurer. They've not disputed that fact. We've asserted it twice, and we've cited a Second Circuit case for that proposition. It's not been disputed. So, with respect, I think Your Honor might have asked the wrong question at the beginning of this discussion. Your Honor asked, well, could this language suggest that medical necessity is part of the coverage determination? That's not enough.
Well, let me ask you this. Does the burden here make a difference? In other words, if there is no dispute on the crucial issues, it seems to me, maybe, and it's a de novo review, how does that all play out?
Well,
in other words, one of the issues is cost. Is proton treatment more costly?
Yes.
You have, I think, conceded in your original motion for summary judgment, you say at page 8, there is no dispute that proton therapy is more costly than X-ray therapy.
I wrote that, Judge.
You did write that. Aren't you bound by that here? Don't I have to assume that for purposes of these cross motions for summary judgment, that proton therapy is more costly?
Interestingly, not according to their argument.
Well, I leave them out of it.
Okay.
It's just you and me.
Okay.
You've made a statement to the court in your brief, in your opening brief, telling me that there is no dispute proton therapy is more costly. Aren't you bound by that statement?
The law, Your Honor, is the court may treat us as bound by that statement, but that it doesn't have to.
And what evidence is there that it is not more costly?
Well, let me back up. I thought that was true when I wrote it. I now know that I was wrong. It is, in the aggregate, looking at averages, more costly, as I understand the evidence. But it turns out that that assumption, when applied to an individual patient, suffers from the logical fallacy of reasoning from the general to the specific. It is not necessarily true that an individual patient's treatment plan is going to be more costly with protons than with IMRT, as an example.
You have filed no expert declaration that would say in Mr. Baxter's individual case it would have been the same or more costly. Have you anything in the record that tells you that?
No, there isn't, because that work has never been done. But what I submit to the court...
So I have to conclude from the record that I have that either it's more costly or it's the same. I mean,
I don't think the court can answer the question in Mr. Baxter's case from the record, because neither side has done the comparison that would be necessary to show in Mr. Baxter's case which it is. And, you know, like I say, when I wrote the sentence the court referred to in my brief, I thought it was true. And I'm sorry that I was wrong, but I was. And it is work that I wish I had done, but I hadn't done it because I didn't know it needed to be done.
Well, but you've got, so one of the issues is cost. How do I decide that? You're telling me that...
I don't think the record is sufficient for the court to decide that.
Well, but these cross motions for some... So I can't, you're telling me I can't decide one way or another on the cost issue based on this record. Is that your position?
That's exactly my position, Your
So
Honor.
let's go to the elephant in the room, really, and that is, are these procedures equivalent? What does that mean, equivalent?
Equivalent in the contract means substantially likely to produce equivalent therapeutic results. The big therapeutic result that is different with protons as compared to X-ray radiation is that protons rely on much less irradiation to non-cancerous bodily tissue. And that is illustrated by this chart that we've put up that's in our materials. But what I brought to court today...
Can you tell me where it is in the materials you filed?
Yes. Page 6 of our summary judgment brief, it's reproduced from the declaration of Dr. Rossi.
Well, you got a lot of briefs. Your opening brief?
Our opening brief, Your Honor.
Let me see if I can find the hard copy. It might be easier.
Absolutely.
Well, it's not all in color, but I have it. Go ahead.
Well, I brought the color one today so you could see it in color. And they've had the color one for some time. Because what this picture shows are bands of radiation in treatment studies. And at the top, the crisscrossing beams are X-ray beams going straight through the patient. And at the bottom are proton beams coming in from the two sides and stopping at the prostate gland. It's color-coded so that you can see different levels of radiation delivered to different parts of the body. So the red part is the treatment dose, in this case 79 gray. Gray is a unit of radiation. And the blue part is basically the collateral damage, showing about 10 gray and ranging up from that.
Well, is it collateral damage or is it possible future secondary cancer caused by the radiation at some later date?
Both. It's collateral damage. That's what causes the gastrointestinal and urinary side effects that are talked about in the materials. It also causes a risk of future treatment. The next point I want to make has to do directly with the most recent declaration of Dr. Rossi, and it relates directly to this issue of how much radiation is there.
Well, why should I even consider this latest declaration?
Because the assertion...
It's been closed. They made a decision in the fall of 2011. They made their appeal decision in February 2012. We've had this motion on the table for a long file this declaration that you say tells me the answer yesterday, late.
They didn't suggest that there was a lack of foundation in this piece of our evidence until their response brief, which is more than a year and a half into this process, as Your Honor points out. And what I need the court to understand is that there is a foundation. And if the court wants to limit consideration of the declaration for the purpose of responding to their reply, by the way, they cite some new studies in their reply that aren't part of the record, and establishing a foundation for opinions that we've had in the record for a very long time, I'm fine with that. But it's critical for the court to understand that Dr. Rossi, when he says we can treat this condition with 2 to 3 times less radiation, that is not plucked out of nowhere, as they suggest for the first time just a couple weeks ago in responding to these cross motions. And it's illustrated by the chart that I've put up there, which is from the first page of Dr. Rossi's letter. It's the second page of our declaration that we filed. And this chart actually comes from a real patient. And it shows 2 lines, one showing radiation from proton therapy and one showing radiation from an X-ray treatment plan. And the total radiation to the body is the area under the 2 lines.
Well, here's my problem. We were having a trial, and the doctor
Right.
came in and said, I've got this unnamed patient, and I'm going to show you a graph that shows me, with respect to this individual, not the plaintiff, here's what the evidence shows. Is that even admissible?
Oh, it's absolutely admissible as a foundation for the proposition that we can treat people for this condition with less total radiation. Because all of these are based on radiation treatment plans, where you figure out where's the tumor, what do we have to hit, how much radiation do we want to hit it with, and what do we have to do to get the radiation into the tumor in the middle of the body, and what's going to get hit in the process. So the purpose of offering this declaration, and I agree with the court, the timing doesn't look very good, but it is in direct response.
It's a little different than what I said.
Fair point, Your Honor. But it is in direct response to a foundational objection asserted by the defense at a very late stage in this overall process, as the court has alluded. So I want to save a little time, so I don't want to talk too much more. But I want to talk about what's the consequence of protons being able to treat prostate cancer with much less radiation to the body. The result is you can edge up the treatment that you give to the cancer in order to control the cancer better. And that's what they did in so-called dose escalation studies. Both parties have talked about them, and both parties have put them in evidence. And what the dose escalation studies show is that you can increase the dose of the tumor and get better cancer control.
Is this the same as what's referred to as the Prague 95-09 study?
Yes.
And then I guess one was the Zetman study, and then the follow-up was the Talcott study, is that right?
Yes. Prague 9509 was a dose escalation study. And an undisputed fact about these studies is that when they dose escalated with protons in Prague 9509, they didn't see the same increase in grade 3 side effects that they saw in dose escalation studies with X-ray therapy. That's undisputed in this case. There's a big fight between the experts about whether that counts. Their experts say, no, we need to look at grade 2 side effects. And we say, no, we need to look at grade 3 side effects.
So help me understand the difference between grade 2 and grade 3 side effects, and when these side effects become known, if there are advantages on one process for side 2 effects, and then stage 3 or side 3 effects, you get it's different. How does the court possibly phrase that?
Well, on summary judgment, I don't think the court can. I think the court can weigh it in a trial with witnesses on the stand, but at summary judgment, I don't think the court can weigh that testimony.
Well, I mean, you both sides have provided me with a substantial amount of information, declarations, studies. What more is a bench trial going to possibly provide?
A bench trial is going to try to provide the court with an opportunity to have the experts here to explain it themselves in person and allow questions to be asked directly of them. It's going to allow the court to assess the experience of the experts and their familiarity with these processes. For example, they have repeatedly asserted that the court can't rely on Dr. Rossi's opinions. They've got all these theories about how he's contradicted himself. Your Honor, I don't know how often the court gets an expert in this courtroom who can buttress his opinions by pointing to his own research published in the Journal of the American Medical Association. But that's what Dr. Rossi is doing.
Well, help me understand, because in looking at the report, well, the defendants suggest, and the report seems to back up the suggestion that the study was not designed to and did not test whether proton therapy was more or less efficient than other radiation treatments. Is that fair?
That's a fair characterization of the study. But studies, the data from study can demonstrate facts that studies aren't designed to test. And that's an important point, because the defense sets up this theory that the only way anyone could ever show that protons are superior is to show a study designed to test that proposition. Our experts say no such study is ever going to exist. They don't even really rebut that contention.
Well, has the follow-up study or other studies suggested the additional radiation is causing other secondary cancers at a later date? Has enough time gone by?
Not with prostate cancer.
Pardon?
Not with prostate cancer. But I want to.
So isn't that the problem? As I understand it, your position is that for the treatment of the cancer itself, they're equivalent, but that because of the high dosage, there's a risk of secondary cancers in 5, 10, 15, 20 years, and that risk is greater with the X-ray process as opposed to proton. Is that kind of where we are?
That's kind of where we are. I would say I think protons are actually a little bit better. It's highly dependent on the treatment dose that you use, but that's a footnote to your
But
own
haven't
point.
all the studies kind of said they're at best equivalent? I mean, haven't some of the leading studies suggested that proton therapy isn't recommended for the type of cancer that Mr. Baxter had?
Not really. I
Well,
want to say two things in response to that, and then I want to sit down and reserve my
All right.
time. The first thing I want to say is, what about these studies that they cite for the proposition that protons are maybe a little bit worse?
Keep your voice up, please.
Yes, there are two of them. One is the Sheets study, and one is the U study, YU. Neither one of them actually looked at what happens with real patients. They didn't look at any patients, actually. What they did is they looked at Medicare data. They looked at Medicare billing and procedure codes, and they gathered a whole bunch of patients who'd had an X-ray treatment of some kind and a whole bunch of patients who'd had proton therapy. And then they used GI, gastrointestinal visits, as a proxy for gastrointestinal problems. There are two huge problems with each, and what they say is, well, after proton therapy, Medicare pays for more gastrointestinal visits and procedures, so that means proton therapy must be worse. There are two huge problems with that. The first is that we don't have any idea what the dose was that any of those patients got who got X-ray therapy. It's not in those studies. If you want to compare one study to another, you need to look at the dose. If somebody doses a patient with 82 gray of protons and then doses a patient with 50 gray of X-rays, probably the guy who got 81 gray is going to have more side effects, because that's our basic proposition. The more radiation you get, the more side effects you get. The interesting question is, what happens if you were to dose with 81 gray of protons and 81 gray of X-ray? And there's actually not very much data out there on 81 gray of X-ray, because nobody tried 81 gray of X-ray until they came up with IMRT, because it was too dangerous to try it with past methods. So what about the Sheets and U studies? The Medicare data they're looking at comes from the mid-2000s. And that data comes from a time when typical doses of X-ray therapy were in the 72 to 74 gray range.
You're giving me a lot of medical evidence here. Is it
all of which...
Is it set forth in your expert declarations?
Yes.
Which ones?
The most recent one from Dr. Rossi.
The one you filed yesterday?
Yeah, the one I filed yesterday.
Well, all right. I understand.
And
I'm going to give you 5 minutes from rebuttal. We've already used it more than a half hour.
all right, thank you, Your Honor.
May I approach the bench?
You may proceed. Oh, yes.
Good morning, Your Honor.
Good morning. Do you have an extra set of these for my law clerk?
I do not,
All right.
but I did give one to plaintiff's counsel.
Okay.
I'd like to start at the beginning of Your Honor's questioning, because I think it's a very important question that I personally grappled with, which is, on this ERISA case, where do you stop? Do you keep adding new studies? Do you look at expert opinions? Do you just look at the paper record? The Ninth Circuit law is very clear. Under the Mongaluzzo versus Baxter-Travenol decision, on a de novo review, the general rule is that the court is limited to the record, and the reason for that is because the court is not having a trial on the merits. The court is looking at the administrator's decision and determining de novo whether it was correct or not correct. Supported?
Well, that hasn't slowed you down in filing all sorts of declarations.
Correct. And so there is an exception to that Mongaluzzo rule, and the exception is where there are complex medical issues in the record, and it would be helpful to the district court judge to understand the evidence in the record, then it would be appropriate to consider evidence such as experts who are helping the court interpret all those studies. Because honestly, when I first read these studies, I couldn't make head or tail of them. And so what we have tried to do is limit the evidence to helping the court understand. Now, I think the court could do two things. The court could say, we're not considering any expert opinions, we're not going to consider anything that's not in the record, and the court will look at it. Or the court could decide that the expert opinions that help understand and give information as to the evidence in the record, the court can consider that. What the court should not do is, if a study comes out tomorrow, let's say there is a randomized clinical trial that compares protons versus IMRT, and that is the definitive answer, well, that is not anything that informs the record.
For the court. You're talking awful fast.
Sorry, and I'm on camera now, too. So anything that helps inform the record, I think, is appropriate to address these complex medical opinions. And beyond that, I think it is inappropriate. And so to have received a declaration 30 days after defendant's response brief to the plaintiff's motion for summary judgment yesterday at just about 5 o'clock, attaching and referencing apparently data that the expert created yesterday, is not appropriate. It doesn't help inform anything. But at the end of the day, I don't think it really matters.
Well, so let's pick up on what you just said. At the end of the day, it doesn't matter. Does that mean that I should consider it? And do you need time to file some response to this?
I think it has ended. I think it ended at the final appeal in terms of new information provided on this topic. So the second appeal was August 2012.
Well, let's, so I understand. Do you have any objection to my considering the third Rossi declaration filed yesterday in connection with these cross motions for summary judgment?
Well, if Your Honor were to do that, then we would obviously want to have a chance to respond to it. I haven't even talked to any experts about these new graphs that he's created yesterday, and there's a new study that he's added, which actually I quick read a copy of it and does not support what he's saying. So there's a number of issues, obviously, with now the third Rossi declaration.
This is a ERISA case. It's de novo. We've got the issue of the burden of proof, but at the end of the day, the court is going to have to decide whether they're equivalent, whether one is better in some legal way, such that the plaintiff would be entitled to recover. How do we do that? And is the record sufficient now with what we have so that I can do that? Or do you agree with counsel that that has to wait for a trial?
I believe the record is more than sufficient to do that right now. If I may just digress for just one moment, because I do want to address the burden of proof since there was earlier argument on that. The court noted that under the medical benefits section of this ERISA plan, there were repeated references to medically necessary, that the coverage to be covered medical services and supplies must be medically necessary. Plaintiff argued that didn't really say that, but if we look at the table of contents, you see under medical benefits, which is right where this medical necessity introduction language comes from, it's the coverage section. Conversely, on an entirely separate page, 26 pages down, are the general exclusions.
Well, it's certainly an exclusion, is it not?
Medical necessity is listed as an exclusion, correct.
And you have a burden with respect to an exclusion. Is that
I do not dispute that.
pardon?
I don't dispute that we would have a burden as to the exclusion. And
so what happens when you've got it in both places? Does the Farley case tell us the answer, or is counsel correct that there are things that distinguish that case from ours?
Farley tells us the answer. And the reason why Farley tells us the answer is that it's on all fours.
I assume these are not in the package you sent us.
Correct. This is part of the administrative record. It's at page 542. And this is the section of the medical benefits, which is in this coverage section. And what, as I understand it, the plaintiff's counsel is arguing that although the underlying section indicates that to be covered, medical services and supplies must be medically necessary, he indicates that the sentence that precedes that somehow takes that away and changes it and makes it into an exclusion or creates an ambiguity. But as this court is well familiar with, that would require the court to do something that you cannot do in contract construction, which is to ignore and treat that sentence as surplusage. Because if you read it the way the plaintiff would have you read it, it would mean that all covered benefits are subject to limitations, exclusions, and provisions of the plan, and medically necessary services are an exclusion. So why are we mentioning it twice? It makes no sense. The other thing that I think makes it very clear that medical necessity is tied to the coverage section, not only the fact that it's under the medical benefits, which is the coverage section, but also it indicates that a health intervention down there at the bottom may be medically indicated, yet not be a covered service, and that's a capped, defined term under the contract or otherwise be medically necessary. In other words, if you want coverage, you must have a medically necessary service or supply. That's very different than saying, let's go to page 26 and look at the exclusion. So just like Farley, which did involve the same identical necessary language in terms of having it in the coverage section and in the exclusion section, we have the identical situation here, which means that the plaintiff bears the burden of proof. But to the court's comment, I don't really think it matters, because I think in either way, Regents has either met its burden or plaintiff utterly fails in his burden. And here's what we are really presented with. It's a very simple question, and the question is, can the medical necessary criteria of the plan be satisfied? We're all talking about the same evidence if you exclude things that are extra administrative record. And so the real issue is, how is this evidence to be interpreted? And we really have three different arguments. The first one, in its simplest terms, is cancer control. And why are we talking about, first of all, why are we even talking about these types of things? And the reason for that is because the language of the contract requires that the services be medically necessary for the treatment of an illness, and it has to be that it's equivalent to other alternative services that relate to the therapeutic or diagnostic results. And so we're talking about results. Results must mean something in that context. It has to mean real people, not hypotheticals. So in terms of what the court has been presented with, the first thing the court's been presented with is arguments about cancer control, prostate cancer control. Which one's better? And no matter which way you look at it, everyone, even plaintiff's own expert, agrees it's equivalent. The next measure that they talk about is this idea that decades from now, people that are getting IMRT might be at a higher risk for a second cancer. The problem with that argument is that there is absolutely no human data available, despite the fact that this technology has been around for a very long time. Dr. Rossi, who's claimed to have treated 9,000 patients with proton therapy for prostate cancer, doesn't present any data that these people have a reduced risk of secondary cancers. And so what we are left with on the plaintiff's side is to argue based on mathematical modeling of treatment plans. The nice photograph that plaintiff's counsel put up a few minutes ago, the Fontenot study, involved 3 patients, treatment plans, and no actual real patients. It didn't look at, did they really actually get cancer? And what they used was a computerized anthropomorphic phantom, and that's at the record REG 199. So they took three treatment plans, and they applied proton therapy treatment plan to a IMRT treatment plan, and in the best case scenario, assuming all things go perfectly, they made some conclusion based on those 3 treatment plans. Same thing with the Vargas study. That's a treatment plan, 10 patients. They want you to assume that based on 3 patients or 10 patient treatment plans, we are now going to leap to the conclusion that somehow secondary cancers are less frequent in protons. And the Schneider study, which is at REG 365, again, it was 30 patients and treatment plans. That's all they have. So there really isn't any scientific evidence to show that protons do better than IMRT or other equivalent radiation therapies for secondary cancers. So the big fight, as I see it, the real legitimate fight, is on side effects. And what do we know about the side effects? There's really only 3 categories of evidence. We know there's no randomized trials doing a head-to-head comparison. That would be the definitive answer to tell us which one's better, protons or IMRT. We don't have that. Okay, so we don't have that. What else do we have? Well, we have clinical practice guidelines. We have the National Comprehensive Cancer Network, NCCN, this is in the record, finding that protons are not a recommended therapy because they can't even prove that they're equivalent, according to the NCCN.
Well, your client used and had and approved that process, did it not, in the recent past? And then it changed its mind.
Yes, and I'm going to explain that as soon as I finish the other clinical criteria because I think they inform that decision. There's also another really important study that came out in 2008 by the U.S. government-sponsored AHRQ, also in the record, and that found that while they may be equivalent, there was no direct evidence that protons were better. There's the American College of Radiologists, who again say it appears that they're equivalent, but no evidence that they're better, and we need more studies. So we have from all the major prostate cancer institutions, finding that perhaps equivalent, but not better. And it is true that in 2008, regions did consider protons, despite the lack of evidence, to be medically necessary. But the important distinction there is twofold. Number one, the definition of medical necessity was different. It did not include the cost issue or the reasonably or likely to lead to equivalent diagnostic and therapeutic results. And the second thing is the AHRQ study came out and the Blue Cross and Blue Shield National Association technical advisory guidance came out against proton therapy as a medically necessary. And so back in 2008, we had a different landscape, different definitions, different national...
How was the definition different?
It did not include the least costly alternative language, and it did not include the equivalent language. And I believe this is addressed in Dr. Rainey's declaration. He was part of the medical policy review, and that's why he was providing that information. And so what other evidence do we have of the side effects? You know, no randomized trials. We have the clinical practice guidelines. Then we have two remaining pieces of evidence. We have one, single comparison studies. There's only two of them. Single comparison study is a study where they actually looked at comparing protons and IMRT in the same study, as opposed to doing a cross-study comparison. That's the SHEET study, which is cited in the record. I'll point out at REG 030, there is the medical opinion by the radiation oncologist, Dr. Zinkin, and she references the Journal of Clinical Oncology and the ASO genitourinary meeting talking about the study that was presented by Dr. Sheets. And then also at 027 in the record, Dr. Sorum, also a radiation oncologist, finding that Mr. Baxter's proton therapy for treatment of prostate cancer not medically necessary, citing the Cone study, which also, citing the additional studies which also relate to the SHEET study, so, and the National Cancer Care Guidelines from 2012. So those are all in the record. And so we have the U and the SHEET study, and what do they say? These are the only single comparison studies between prostate and IMRT. They say, you know, they're basically equivalent. Prostate cancer does worse on some measures.
Is this something that's in the handout?
This is in the handout. This is exhibit number 1. This is a graph portrayal of the SHEET study. The IMRT therapy is the blue, and the proton therapy is the red. Now, absolutely, plaintiff's expert can take pot shots at this study, but there's only 2 single case studies. They don't offer anything else. And this study looked at 251,000 patients during the same time period. And so I think it is the best data that one can get in terms of a direct comparison, even in a non-randomized way. And so it went through and looked at these different types of issues. GI is genitourinary, and that involves things like the bladder and erectile dysfunction and these other things. And then obviously the other ones are the bowel issues. And so for the GI, you can see that there were more medical appointments, medical billing, medical procedures after people got proton therapy. Same thing for the diagnosis. When you get to the urinary non-incontinence procedures, they're pretty much the same. When you get to the urinary...
Don't we have to stop after the first two? I mean, if it's not statistically significant... Sure,
yeah.
We really, doesn't add much to the mix, does it?
Right, and so those, I think what you could do is everything on the rest of that chart, you could say it's basically the same. And so the question is, okay, so we have some statistically significant differences, worse for protons for those two measures. It does not support the idea of superiority, and if you ignore the first two measures, it does support the theory of equivalence. So there you have it, and the U study is very similar to that. So the final piece of evidence, and this is the only evidence that the plaintiff looks at, and it is the least reliable evidence. It is this concept of a cross-study comparison. And what that means is there was a study done with regard to dosages and side effects for proton patients. And then there was a whole separate study done by someone else for side effects relating to patients who received IMRT. And what the plaintiffs want to do is say, let's take study A, having to do with the proton side effects, and let's take study B, and let's make some analysis about them to see which one's better. As Dr. Beer explained in his declaration, that is an absolutely dangerous way to go about doing science, because the metrics that study A used versus what was used in study B can be completely different. And so the proposition that we're going to use these cross-study comparisons is fraught with all kinds of problems. But you know what? Just for the sake of looking at all the arguments that they're raising, let's go there anyway. And what they like to do is they like to take this Prague 9509 study, and that's the Zeitman study, it's in the record, and they like to use that as their basis, their benchmark. And just to remind the court what Prague really dealt with, Prague had, of course, nothing to do with comparing IMRT with protons. And the reason why it couldn't ever do so is because the individuals in that study all received the exact same dosage of X-ray radiation, and then there were two different arms that they were studying. The proton therapy at 19.8 gray, and then the higher dose arm at 28.8 gray proton therapy. So that's what Prague is all about. There was no higher X-ray radiation in Prague, so it absolutely cannot stand for the proposition that it evaluates IMRT versus protons. Okay, so what did Prague actually show? It showed what one would expect to show, that when you got more proton radiation, you got more side effects. The acute toxicity, the word toxicity is used as a stand-in for side effects. Another word for it is morbidity. And so when you see, for example, the first column is GU, that's genitourinary. At the low dose arm, again, the low dose proton arm, you see that there is more blue, which is a grade 1, a very small side effect, than you see in the high dose arm, which is the grade 2. And then look at the green. This is what they're focusing on, the green, the grade 3 effects up there. That's what the plaintiffs are focusing on. They want to ignore the red. When you look at the the GI effects, the low dose arm, you can see how it is significantly different than the high dose arm. So when you get more proton radiation, you get more side effects, preliminary, especially grade 2 side effects. Well, what are grade 2 side effects? Grade 2 side effects Dr. Rossi said, well, who cares about them? They're not life-threatening. Well, there are things like urinary incontinence, rectal bleeding, kinds of conditions that require analgesics and medical attention. So they are things that, in fact, can be measured because people go to the doctor for them. They're so disturbing. Okay, so that's the acute toxicity. And again, this is PROG. And then we're going to look at the late toxicity.
Do you have is there a similar chart for the grade 3 toxicity?
Grade 3 is included as the green.
Thank you.
It is a tiny, tiny percentage of the overall. So late toxicity just means that these side effects showed up later in time. And you'll notice...
And when we have this number 0 to 100, what does that reflect? I mean, what are we measuring?
Those are measuring percentages, is my understanding. And you'll see the same effect, especially when you go to the GI. You're comparing the low-dose proton radiation to the high-dose proton radiation. You have a big bump in the side effects. So where does all this leave us? Let's not forget, look at the grade 3. There were 195 people in the late toxicity study. The actual numbers, I'll show you in a minute, of people that had the grade 3 side effects that the plaintiff has solely focused on were 2. 2 patients. That's it. So they want to take 2 patients who had these grade 3 side effects, ignore all the grade 2 side effects, and make leaps and conclusions that, well, protons must be better because there wasn't such a huge difference in the grade 3 side effects. The way the plaintiffs have used the PROG study is demonstrated by the following chart, and this is actually in the record. It's at docket 25-1, page 16. So what they've done then is they've taken...
And I'm sorry, this is your exhibit?
It should be exhibit 4, I believe.
Well, it looks like it's exhibit 5 in this handout.
Okay, it might be exhibit 5. Sorry about that.
So if are they misplaced?
I probably have pulled mine apart, and now so I don't remember what exhibit it was.
Right.
I believe it is 5.
It's captioned corrected defendant's motion for summary judgment?
Yes.
25-1, page
Yes.
16?
Yes.
All right.
Yes. And so this shows what the plaintiffs have used this PROG study. And remember, again, where have we been? No randomized trials, no clinical practice guidelines supporting that proton therapy is better, no single case comparisons showing proton therapy is better. So now we're into the comparative studies, which is a dubious thing to do anyway. And we're taking PROG, in which 2 people had the grade 3 side effects, and we're making these leaps and conclusions. And so here we go. The first study is this Elicus study, and it was in IMRT only, and they were looking at the dose of 81 gray, and then they were looking at side effects. And the shaded part is the part that the plaintiff does not include in their analysis. That's the grade 2 side effects. And then there's the grade 3 side effects for GI and GU. The Zalewski study is, again, another IMRT only study. And it had, 881 gray for some reason, a much different number than the Alicus study. They had less on the grade 3 side effects. When you get to Zeitman, Zeitman is the PROG study. For the grade 2 GU side effects, it had more than any other study. If we're going to do these dubious cross-study comparisons, let's do them fairly. 27% of the people in the Zeitman study suffered grade 2 side effects, and you compare it to the IMRT studies, it's significantly lower. Let's go to their grade 3 for Zeitman, which is the PROG study. 2%. That represents 4 patients.
Is it 2% or is it 2 patients?
So there were 195 people in the study. This represents 2%, 4 patients. For the GU, the 1% represents 2 patients. So Prague found 2 patients with grade 3 GI side effects and 4 patients with GU grade 3 side effects. That's it. That's what their entire analysis is based on. And it doesn't stand up on the grade 2 anyway. And then when you get to Mendenhall, that's a proton therapy only, and it has, again, a higher incidence of grade 2 side effects than the 2 IMRT studies. And it's about equivalent when you're looking at the grade 2 GI, and it's less when you compare the grade 3. So these numbers, the 2 patients and the 1% and the 4 patients and the 2%, they're not even statistically significant. And so if we look at using those as the comparator, the whole thing falls apart. Number 1, on grade 3 alone, but number 2, especially if you look at grade 2. Now, Your Honor made a very excellent point, which I thought was, how do we decide what we're supposed to look at for evaluating whether or not medical necessity is met? And you get back to the plan language, which talks about therapeutic or diagnostic results. A therapeutic result is that you don't suffer side effects sufficient that would cause you to have to take pain medication and go to the doctor.
Are you reading from something, or
No.
are you telling me that?
No, I'm telling you that.
All right. Well, where does it say that in your plan?
Well, the phrase therapeutic or diagnostic results is in the definition of medical necessity. And a reasonable interpretation of that, I think the only interpretation, is that it has to, first of all, relate to real people. And number 2, a therapeutic result means a result that implicates the person's treatment, the person's betterment. If the person is having significant side effects, that's not implicating their betterment. It doesn't mean that it has to be a life-threatening issue before you count it in terms of therapeutic results. I am running out of time. I would, if the court would be interested, like to address a little bit about this secondary cancer issue, because I do think that's, for some reason, an incredible focus of the plaintiffs, and it might be helpful to go over it. There are a couple of important assumptions that are being made by the plaintiffs that need to be understood before the court can evaluate where the plaintiff would like to take them. And the first one is they make the statement that secondary cancer risk is the big risk of radiation therapy. That is absolutely not true. Docket 29, page 6, which is Dr. Beer, indicates that that is not the big risk of modern conformal radiation techniques. And in fact, if it was the big risk, one would wonder why Mr. Baxter did not follow the advice of his own physician and get surgery. So this is a very, very small risk. In fact, it's so small that no one's even studied it. The second assumption that is being made in the plaintiff's data is that there's this big discrepancy in dosages between the IMRT and the proton dose. And this takes a little bit of explanation, but that assumption is also incorrect. Docket 28, Docket 29, page 6, paragraph 9. Also, there's a reference to the fact that Mr. Baxter did not get any dose escalation for his own treatment. In fact, it was undisputed that the dose prescribed for him was no higher than IMRT, and there was no dose advantage, and that's at Grimm, docket 20-2, page 7, Beer, 29, page 6, paragraph 9. He's getting the same dosage because it's a standard dosage, standard proton, standard IMRT, very, very similar. Where the plaintiff wants to make a big distinction is the fields that are treated, and so the way theoretically proton therapy works is that it is shot into your body, and theoretically it can stop. IMRT, which is the most modern radiation X-ray technology, goes in through 6 different entry points. And so we don't dispute that the amount of the field is larger that receives the IMRT dosage than the proton. But before we make the conclusion that therefore there must be more radiation, there has to be an understanding that the dosages used by the IMRT in this greater field are lower than the dosages that are used by the protons. And very interestingly, the new study that we see attached to the belatedly filed declaration of Dr. Rossi.
This is the one that was filed yesterday?
Yes, I did have
If you're going to start relying upon
Okay.
it,
If the court's not going to rely on it, I'm not going to argue it. But Dr. Grimm makes this point very clearly. He says that there are protons, unlike the theory of protons, the actual practice of protons, they don't stop, when they hit the body and they go right to their target and they magically stop. There's all kinds of problems when they hit tissue density. There's issues with neutron scatter, and honestly, I don't understand all this, but I do see in the literature that at docket 28, page 3, there was an article by Zhang talking about the effect of anatomic motion on proton therapy dose distribution and what happens in proton therapy.
I don't understand it. I certainly don't understand it either.
There's hotspots. There's hotspots that go outside the target. That's the issue. And those hotspots are high dose. So when the protons go awry, they go awry in a high dose situation. When the IMRT...
Well, let me just interrupt.
Sure.
That's not the dosage that Mr. Baxter received because he didn't need it. Is that fair?
No. The dosages that you typically are being presented with are the dosages to the target. In other words, the cancer. This is what happens when, in the real world, not when you look at a treatment plan, but when you actually administer that dosage, what happens to it? It hits, there might be gas, there might be some kind of tissue density, there's neutrons that make it scatter. It doesn't do exactly as planned. And so there are dose distributions with proton therapy that are high dose, that are outside the target. And so what we have is a situation, and Dr. Grimm explains this very well in his declaration filed in response to the plaintiff's motion. We have 2 unknowns. We have what happens when a greater field but a lower dose of IMRT is delivered. What happens 20 years from now? And then we have another unknown, which is what happens when these protons delivered at higher dosages outside the target field but a smaller field. What happens with secondary cancers 20 years from now? The only reasonable conclusion you can make is we don't know. We don't know which is better. We don't know what the impact of the clinical outcome will be. It's exactly what Mendenhall, who's a proton therapy expert, says. But plaintiff wants you to say, well, we have to assume it's going to be better just because of Hiroshima and some kind of atomic bomb studies that show more radiation is bad, but that is a fundamental misunderstanding, and I think really not a fair way of looking at this. And so on all the measures that they've come up with, this dubious theoretical secondary cancer issue, there's no evidence that protons are superior, and there's certainly evidence that IMRT is at least equivalent. On the issue of the side effects, again, IMRT is at least equivalent, no evidence that protons are better. And on the cancer control, I think it's almost admitted that cancer control, it's equivalent.
Well, does the proton therapy result in lower total body dosage?
We don't know. And the reason we don't know is because of these hotspots.
You haven't mentioned cost. You want to address cost for
Sure.
a moment, and then your time is basically up.
Thank you, Your Honor. I appreciate the additional time. I think the place to start with is plaintiff's admission to the court, which the court has already gone over. The Region's policy, which is in the record at REG 111, says that charged particle irradiation with proton beams is more costly than IMRT alternatives. The policy was based on a analysis that was on a per unit comparison, proton versus IMRT. And so that completely guts the plaintiff's argument that this was all in the aggregate. I mean, they literally looked at how much does a unit cost, and it was more than double. Then we have, and this is all at docket 22, page 3, paragraph 9, also docket 34. Then we have in the record, docket 19-4, page 3, a 57% price differential between proton radiation and IMRT cases when you looked at each person. And so there you have that.
Do we have to look at the cost to the plaintiff himself, or average cost? How do we address this cost issue?
Well, I thought about that, and remember, we're here on a request for a pre-authorization. That was his claim. And so I don't think it makes any sense to have him go through the therapy, figure out how much it costs, and then deny his coverage. It has to be on fair metrics, either on a per unit or in an aggregate. We know that proton treatment that Mr. Baxter underwent took 9 weeks. We also know from Dr. Beer's declaration that IMRT does not take that long. And so just by looking at the unit cost differential, that answers the question. So I think there is ample evidence in the record to make the conclusion, not only based on the plaintiff's admission, but everything that's in the record, that protons, I mean, it's repeated. There's at the NCCN, docket 19-2, page 17, proton therapy, the high costs associated with proton facility construction and proton beam treatment are high. At the Journal of New England Journal of Medicine.
Slower, Counsel.
Sorry.
Reading awful fast for the court report.
The Journal of New England Journal of Medicine, and this is at ARREG 379. Proton therapy is a high-profile, high-cost treatment. Undisputed that proton beam facilities cost between $100 million and $200 million. That's docket 21-2.
Well, there's lots of information in the record. But is it not fair to conclude it's impossible to tell in Mr. Baxter's case whether or not the cost was greater or not?
I don't think it's impossible to tell. The only way that there could even be a question of fact based on what you have in the record is to make the assumption that Mr. Baxter was going to undergo 18 weeks of IMRT or more, because we know on a per unit basis proton therapy is double, at least double. And so unless one were to assume that he's going to go through double the treatments for IMRT, which is not a reasonable assumption, then you have enough evidence in the record to decide that it is significantly more costly.
Thank you. Time's up.
Thank you.
May I have a couple minutes, Your Honor?
Well, I think I suggested you had 5 minutes I was going to give you. Is that going to give you enough time to make your points?
Yes.
All right, go ahead.
Well, Your Honor, defendants' doctors, I guess, have suggested there are hot spots and neutron scatter. I don't know what neutron scatter is. Dr. Rossi, in his second declaration, responded to those and says, no, that's not a problem. He treats these patients with proton therapy all the time.
Please keep your voice up.
Yes. If we really wanted to know what the practical difficulties are in treating a patient with proton therapy, we ought to get the doctors who do it here in the courtroom in a trial. Dr. Rossi's the only one who does it. Let's talk about the record for a second. Counsel placed heavy reliance on the Sheets study. It's true that the Sheets study is in the record. The other thing in the record is the opinion of Mr. Baxter's doctor at the University of Washington about the Sheets study.
Refresh my memory on the name of that doctor.
Dr. Larimore, and this is at page REG 01, 9-2 of the record. And Dr. Larimore's opinion about the sheet study in the record is, some research has suggested that proton therapy may be associated with a higher complications rate for certain procedures than other forms of radiation therapy for prostate cancer. However, the complications rate discussed in this research relies on crude Medicare procedure data rather than an assessment of true complications from radiotherapy and does not accord with the outcome data reported from facilities currently using proton therapy to treat prostate cancer. In the defendant's reply brief, at page 11, they cite the U study, and they give us a citation, Journal of National Cancer Institute 2013. This is at line 2 of page 11. And the reason they give us that citation is it's not anywhere else in the record that we can go read it. Dr. Rossi's third declaration filed yesterday responds directly to that issue, talking about the fact that these Medicare patients received less total radiation because they had IMRT at facilities across the country, whereas we know that the proton patients in that same group received more radiation. We agree, more radiation is going to lead to more side effects. The issue is what's a head-to-head comparison going to look like. And the only way to do a head-to-head comparison is to do the cross-study comparisons that have been discussed. And it's not, I mean, we're not the ones doing it. It's out there in the medical literature. That's what the experts rely on. And it's the same experts that rely on the grade 3 studies to determine the safety limitations of the treatments. If I'm not allowed to submit a declaration from an expert responding to something cited for the first time in reply, I don't know what I'm allowed to respond to. Same reply brief. Let me talk about secondary cancer. Yeah.
Address that. I'm concerned. I'm very reluctant to even suggest this, but don't I have to give the defense an opportunity to submit a response to your response, which was in response to their brief? I mean, where do we stop?
I don't have a problem with it, Your Honor. I'm happy for them to submit whatever they want and then stop. And the reason I say that is Your Honor asked the key question to counsel just a few moments ago, and that is, isn't it true that with proton therapy you can give the same dose with less total radiation? And the answer from counsel was, well, I don't know. The answer from our experts is unequivocally yes. And the third declaration from Dr. Rossi clearly gives a foundation for that that's absolutely admissible under any sense of the federal rules of evidence. If they want to come in and respond to it, that's fine. All it does is prove that we need a trial if that's going to be an issue in dispute. But I don't think it really is an issue in dispute. It's unequivocal. You can give the same dose with less total radiation. And on the issue of dose escalation, they said, well, Mr. Baxter didn't need dose escalation. At Loma Linda, Mr. Baxter had a dose of 81 gray of proton therapy. That's as high as anything in any of the literature before the court, because it was the dose escalation studies that proved that's an effective way to control the cancer, and with protons you can do it without creating massive secondary malignancy risk. Let me conclude with that issue. Dr. Larimore's opinion from the University of Washington, Mr. Baxter's treating physician and the chairman of the Department of Radiation Oncology at that institution, who would be a witness in a trial, tells us in his opinion, based on current data, proton therapy is likely to lead to reduced risk of secondary malignancy and therefore a superior outcome in a patient of Mr. Baxter's age and life expectancy. Extreme examples are the easiest ones to grapple with. Let me talk again about the defendant's reply brief. Page 5, footnote 2 of the defendant's reply brief has another citation to something else that's not in the record. That's why they've given us an HTTP website address on where to go find this. And they attribute again, contradictory statements to Dr. Rossi. Well, here is that article. In the field of radiation oncology, nobody thinks that proton therapy is not a really good idea for pediatric cancers. And it's because of the risk of secondary malignancy. Why? Because those patients are going to live for a very long time. And in that article, cited by the defendants for the first time in reply, it says it is true that the initial cost with proton therapy is more than X-rays, but when you follow the young child throughout the course of their lifetime and find that their IQs are higher with protons, they don't need hearing aids as often, they don't need special education as often, they don't need growth hormone replacement as often, and they don't develop as many radiation-induced cancers. When you add up all the costs of these long-term side effects of X-ray therapy versus reducing those complications with proton therapy over that child's lifetime, then proton therapy becomes the far less expensive way of treating that child. That conclusion is not based on any randomized study to prove that it's better to give kids less radiation. It's based on the yes.
But Mr. Baxter was no kid.
He's no kid. He's no kid, and I'm coming to that point.
I'm not understanding how that.
He's no kid. He's no spring chicken. He's no spring chicken. But the point is this. We've got the chairman of the Department of Radiation Oncology at the University of Washington saying that in this 51-year-old that I represent, and that's a young age for this diagnosis, he's going to live with the consequences of this treatment for a very long time. And we know that radiation causes cancer. That's not in dispute. We don't need a randomized study to determine that. The field of radiation oncology didn't need a study to determine that with young kids, and we don't need a study to determine that with a 51-year-old either. We would submit, Your Honor, we've shown clear evidence of reduced risk. That's an improved outcome. That makes the treatment superior for this patient. Because they have the burden of proof, we ask for summary judgment in our favor.
Thank you, counsel.
Does the defense want an opportunity to submit in the next 10 days a responding declaration?
Only if Your Honor allows the third declaration of Dr. Rossi.
Well, it's been submitted. You wanted to even talk about it, and then you backed off it. I think it's not entirely clear to me exactly how this de novo review works when someone has made a decision based on a policy a year and a half ago, and to what extent all of this comes in. And you know, in 20 years, we'll know a lot more, won't we, about proton therapy and how it compares to these other therapies that are being talked about. We don't have 20 years to decide this case. We need to resolve the summary judgment, and if I can't resolve it on summary judgment, we'll try it in September. So do you wish... So let me tell you this. You have 10 days. Let's just give you a date. Well, you have... So I'm going to say any supplemental declaration should be filed by Monday, July 8.
Thank you, Your Honor.
And I'm going to order that no further declarations, briefs, papers, references, nothing be filed. I think we have a substantial record here. Obviously, I'm going to take under, and if you conclude that you're not going to file a supplemental, if you would just advise counsel and the court, so we'll know that we have our record complete for purposes of trying to resolve this very challenging and fascinating question or issues relating to prostate cancer and its treatment, which is of keen concern to all of us. And I commend the lawyers for all of the excellent briefs and declarations you have already provided to me, and the argument today. You don't make it easy on the judge, but we'll attempt to resolve it on the motions if we can. If we can't, we'll be looking forward to seeing you in September. So have a nice day. We're in recess.
Thank you, Your Honor.
Thank you. All rise, please. Court is in recess.